A resumption of debate on second reading, access to information bill.
When the Assembly adjourned on Wednesday, the 17th June 2020, the question before the Assembly was a motion by the Honourable Minister of Information and Communication Technology that the bill be read a second time. The Honourable Becker adjourned the debate, and I now give him the floor. Give her the floor, sorry.
Thank you, Honourable Speaker. Honourable Speaker, Honourable Members, in 2017, the Institute for Public Policy Research, IPPR, released a report on a study in which it investigated how various cross-sectoral entities and stakeholders would be responsive to specific information requests from their researchers. Just over 100 public, private and civil society organizations took part in the study. The outcome of that study conducted by IPPR in 2017 highlights to us why having a bill like the one before us is so important. Out of the more than 100 public, private and civil society organizations that were approached with requests for information, 80% of all those institutions and organizations did not respond and could not provide the relevant information that was requested. Furthermore, 85% of state-owned enterprises who were approached for information during the IPPR study were unresponsive, and only one SOE responded with the relevant information requested. Based on this unacceptable and shocking outcome from the IPPR 2017 study, we should all agree that access to information is one aspect of our democracy that should be improved. Honourable Speaker, Article 21 of Chapter 3 in the Namibian Constitution grants freedom of speech and expression to all Namibian citizens. More importantly, Article 21 also grants the media the right to access to information. Furthermore, the United Nations General Assembly in 1946 adopted Resolution 59, which grants access to information to all people through freedom of expression. Namibia is also a signatory to the United Nations Universal Declaration of Human Rights, UDHR, which forms the basis of Article 21 in the Namibian Constitution. In 2002, the Namibian Parliament also ratified the SADC Protocol on Culture, Information and Sport. That particular protocol stated that the need for member states to create, maintain and strengthen the institutional frameworks that empower access to information for citizens. It is then very unacceptable that with all these international conventions that we are signatory to, that the Access to Information Bill has taken this long to be tabled before this August House. Honourable Speaker, Honourable Members, the importance of the Access to Information Bill before us in this August House cannot be underestimated. This bill is the catalyst to the creation of an office that will eventually play a pivotal role in our democracy. It is hence very important that we properly scrutinize this bill and do not rush it. There are fundamental problems with this bill. Firstly, although the powers and functions of the Information Commissioner are outlined quite explicitly under Section 9 of the bill, the qualifications for appointment under Section 7 are quite vague. We submit that Section 7B be amended and state clearly that the Information and Deputy Information Commissioners can only be admitted legal practitioners of the High Court of Namibia. This is because the powers and functions of the office as outlined in Section 9 are so technical and legal in nature that it can only be a legal practitioner who can fulfill those functions diligently. Furthermore, the Information and Deputy Information Commissioners must be legal practitioners with special expertise and knowledge in the field of information. Furthermore, we find a particular provision under Section 8 dealing with the disqualification for appointment of Information and Deputy Information Commissioners very problematic. At Section 8E, it is stated that a person does not qualify for appointment if the person has been convicted of an offence and sentenced to imprisonment without the option of a fine, excluding an offence of a political nature committed before the date of the independence of Namibia. Although this is in line with the Namibian constitution, it is a flaw in the system which must be rectified. People with criminal records of any nature must not be given the chance to serve the public in such important public offices, such as the one we wish to establish here. It is a major flaw in our constitution, and we as legislators must proactively make sure that this is fixed. This is exactly the reason why we have many public representatives with criminal records and questionable integrity in public office. Honourable Speaker, honourable members, perhaps the most concerning part of this bill is that in case of a vacancy under Section 15, the President is given an explicit right to appoint an acting information and deputy information commissioner without the approval of the National Assembly. Can the Honourable Minister please clarify to this House why the ordinary process of appointing an information and deputy information commissioner as outlined in Section 5 has to go through the selection committee and the National Assembly, but not in the instance of vacancy at Section 15? Is this not a deliberate innuendo to capture the process by the Presidency and the deeper powers of state? We submit that it is. The Information and Deputy Information Commissioner must strictly be appointed as envisioned in Section 5 of the bill, even in the instance of a vacancy. Furthermore, there is a deliberate attempt to capture the office at Section 17(1) of the bill. At that particular provision, it is stated that in the performance of his or her functions under this Act, the Information Commissioner is assisted by the staff members from the public service made available for that purpose on assignment or secondment as the Prime Minister, on the recommendation of the Public Service Commission, made direct by notice in the Gazette. This is a recipe for disaster and will lead to the inevitable capture of the office of the Information Commissioner. There must be clear-cut guidelines as how the staff in the office of the Information Commissioner will be appointed, and this bill does not outline that process clearly. Honourable Speaker, honourable members, as with all things African, the implementation of this bill is very vague. There are no powers and functions outlined for the information officers as outlined in Section 22 and 23 of this bill. The appointed information officers at public and private entities are then left to wonder on exactly what their functions and duties are. Section 22(2) is also very problematic. This particular provision grants the right to the heads of public and private entities to act as the information officers if they fail to appoint the information officers. This style of implementation grants too much power to heads of entities. At worst, it will lead to very corrupt heads of entities not to appoint information officers at all in order to hide information and avoid possible prosecution. What should happen preferably is that this particular provision must be peremptory and not directory. The heads of every entity must be compelled to appoint an information officer, and it must not be an option. Honourable Speaker, the implementation time frame under Section 24 is unacceptable and will take too long. Why must public entities be granted another 12 months after the commencement of the Act to give their implementation plans to the Information Commissioner? We propose that implementation plans must be given to the Information Commissioner within a period of 3 months after the commencement of the Act. There is no reason whatsoever to keep delaying the process. This bill is very important, and not only to those in media and communications, but also to the ordinary Namibian men and women. Honourable Speaker, honourable members, in conclusion, The bill in principle is genuine, but the overall implementation in detail is missing. PDM therefore proposes that this bill be referred for further scrutiny to a relevant standing committee of Parliament in line with Rule 37(1) of the standing rules in order for inquiry in the report under 40. I thank you.
Thank you. Honourable Tony Noyoma.
Thank you very much, Comrade Speaker. I rise to give my support.